Friends, if you have asylum case in immigration court, or your affirmative asylum case may end up in immigration court, which is virtually anyone and everybody, you need to watch this video. In this video, I'm going to cover the most recent changes with regard to asylum claims in court and what Board of Immigration Appeals recently ruled about the most common types of issues that arise in connection with asylum cases in immigration courts. So thank you very much for watching. My name is Alena Shautsova. I'm an immigration attorney from New York. I use my social media to educate public on various issues of United States immigration laws, as well as share my tips, advice, and I regularly post live sessions where I answer your guys' questions live and discuss the most recent immigration news. Thank you very much for joining, and let's start. The first big change that you need to be aware of relates to something called pretermission of asylum claims. This is when an immigration judge, after reviewing your asylum submission, decides that you do not have a case. It may happen during your master hearing, it may happen before or at your individual hearing. It means that an immigration judge decided that taking all facts that you submitted before them, accepting them as true, those facts do not and cannot constitute a viable claim for asylum in the United States. It means that you have to prepare your cases very well, even already before and prior to your master court hearing. Very often within the past years, I saw cases that were not prepared at all but filed with immigration court, almost empty I-589 forms, application for asylum. People would not submit any evidence in support of such pending cases and would not even bother to submit a declaration, this story explaining how they qualify for asylum. It's no longer so. Remember that each case has to be submitted very thoroughly as early as possible if you are in immigration court. Number two, unfortunately, the Board of Immigration Appeals recently ruled that people who entered the United States without inspection or parole are subject to mandatory detention. You need to be aware of that. Why? Because if you have court appearance coming up, you may be subject to ICE enforcement and detention. There is not much you can do apart from requesting that your hearing would take place online. Typically, it is much easier to do so if you have an attorney and it is a master court hearing. That you need to know about this mandatory detention trend. You also need to know that there is a federal class action lawsuit which is currently pending, trying to remedy this situation. But for now, the decision of the Board of Immigration Appeals in the matter of Hurtado stays, and it means that you may be subjected to that mandatory detention and you will have to file a habeas corpus petition to fight your way out of that immigration jail. Recent Board of Immigration Appeals decisions. One of them is matter of JHMH, issued just on October 7th, less than a week ago. According to this decision, an immigration judge does not have to accept party stipulation. Party stipulation is when an attorney for the respondent, for the immigrant, and prosecutor agree on some aspect of a person's case. So, in that particular situation, in that case, the immigration judge did not agree to whatever the prosecutor and lawyer for the party agreed upon and ordered the person deported. It means that it can be applied, this decision, to your case as well. Now, the stipulation between prosecutors and lawyers are going to be less important, and your attorney will have to proceed with the full questioning you on the record with regard to the relief you are seeking, regardless as to what the prosecutor and your lawyer agreed upon before the hearing. Why does it matter? It matters for the appeal, because if the record is not developed, if this questioning is not developed on the record, if the judge orders you removed, you simply will not be able to appeal that decision effectively. Another very important case refers to imputed or perceived particular social groups. Why does it matter? Well, because recently we have a lot of cases where we argue that so and so cannot return back to their home country because the government or some non government groups are going to view them as a member of a particular social group. That person is not a member of that group, but those groups may view them as such. And this is a very important decision, matter of LALT. According to the decision, this claim, this legal structure of asylum claim is going to work only if the perceived or imputed group that you're trying to argue you're a member of is also socially cognizable in your home country. In other words, if the group exists regardless of your claim, it does exist regardless of your claim, then you may win your case. If it's not socially cognizable, then you will not be able to win your case, regardless of how the government or those groups you're trying to avoid in your home country are going to view your membership in that group. That particular case that I'm referring to relates to perceived gang members, but the rationale, the explanation behind the case can be stretched to other social groups. Let's say a perceived group of traitors in one's country. Let's say we take a Ukrainian conflict, right? And somebody says, well, I am from the east of Ukraine. I will be perceived as a traitor in my home country. I'm not, but that's what the others may think of me. So now you will have to show that there is such a group of traitors in your home country. Well, it may be a choppy example, but nevertheless, you need to know about this legal problem that now we have in our asylum cases, and of course, you and your attorney will have to address it. Finally, a very important case, matter of JA, that was decided on August 8, 2025. In that case, a person lost their asylum claim because they could not prove in the United States immigration court that they were in fact innocent. The person asked for asylum and also disclosed that in their home country, the government was pursuing certain criminal charges against them, which were not purely political charges. And the government of the United States, the immigration judge, stated that there is no sufficient evidence to show that those charges are not reasonable, are not grounded in fact. In other words, well, we do not know, you may be guilty. And for that reason, persons' claim for asylum and relief under Convention Against Torture, those claims were denied. It tells us that in every case where an asylum seeker also is charged in their home country under a statute that is not purely political, you have to prepare to prove your innocence in the United States Immigration Court. Otherwise, you may be disqualified from asylum in the United States. Very, very important to know this. Well, I know these updates are kind of technical, but I hope that if you hear something that reminds you of your case, you will please discuss the situation with your attorney and be well prepared for those challenges that I'm sure the prosecutor and the immigration judges are going to bring up against you and your claim in immigration court. Thank you very much for watching. Please like and share this video if you find it helpful. Of course, don't forget to sign up for my channel, and I hope to see you soon.